we're hoping to talk about this afternoon, it is about an exploration of some of the issues that presented themselves before the courts, as it may relate to some areas of your work. Dr. Elmer talks about healthcare, social care professionals talking a different language to the legal profession. I think it was once described to me about lawyers and healthcare professionals living on different planets. Yeah, so because we live different ways as professionally operating, which I think is probably a polite way of saying that I'm on another planet, but the case or not is the moot point. In terms of the areas that we thought we could usefully talk about from the information that was sent out, it talks about exploring medical legal issues as it relates to the issue of brain injury, and whether indeed there has been one or more related cases insofar as the courts are concerned, so it's what we're saying to you there. But also recognising that the stuff that you're dealing with may find itself in relation to a civil claim, may be involved in stuff to do with tribunals, it may be stuff to do with court of protection, it may be stuff to do with a combination of all three, yeah? Or indeed may ultimately end up in relation to before the coroner at the inquest. So what are we dealing with? And we thought we needed to remind ourselves of some basics really in relation to the fact that we're dealing with two separate concepts, are we not? One of which relates to mental disorder and one of which relates to mental incapacity. And recognising that there are two separate legal frameworks that are operating in relation to that. But I'm sure you'll be able to help me understand what they are shortly. And for those of you that have been on sessions with us before, we tend to be quite interactive, so we'll be looking for answers from yourselves. Yeah, so what are those concepts? Because they are legal concepts, yeah, concepts of mental disorder, concepts of mental incapacity. And also, as a critical point here, if you're involved in assessing capacity, it was interesting to listen to some of the carers' perspectives this morning in relation to their involvement or lack of involvement in some of the professional processes, yeah, particularly about how you get to a position of assessing a person's capacity. To illustrate the point, there have been in excess of 19/20 senior court decisions since April 2009, yeah, which have highlighted that health and social care professionals have got it wrong in relation to assessments of capacity. And that fundamentally, what we're failing to disregard is that issue there in relation to capacity or disorder. What is it that we're dealing with? So that's what we want to talk with you about. We'll also try and illustrate that there are some issues about which expert's evidence is to be preferred, if at all, by the courts. But also what's the difference between all of the different labels that are knocking around out there, between a psychiatrist, a neuropsychiatrist, a neurologist, and so on. Yeah, so who would the court be looking for in relation to assisting them on particular issues? And again, what we'll then get to are some case examples over the last number of years, in particular, certainly Richard's had direct involvement with in terms of trying to make a difference for people that have been affected by brain injury or brain disease. So, mental disorder, mental incapacity. Anybody help me? It's normally about 7 seconds we have to tolerate silence until somebody feels the need.
He's one temporary and the other permanent?
Yep. But thank you for trying. Yeah? Because these are fundamental concepts that you are dealing with, are you not, on a day-to-day basis? Yeah, and sitting behind each of these two here, mental disorder and mental incapacity, is a legal stroke statutory definition.
We want the mental health and give us the mental capacity.
Okay, so what do they mean?
Mental disorder is
what?
Of the mind.
Is what, sorry?
What mental, sorry, what is what you said?
Well, these are legal definitions that have a direct bearing upon your day job.
One relates to Mental Health Act, which is mental disorder in
Yeah.
1983, and mental incapacity, the legal framework is the Mental Capacity Act.
So do we know what the legal definitions are that you're dealing with?
I think it's to do with impairment or dysfunction of the development of the brain.
Okay? Because the issue is about whether you think it is or in fact you know it is. Yeah? Because the expectation is it should be the latter. Okay? That you know that that's what the law says as it relates to your day job. Yeah? Because if you don't know that framework, then how can you actually go forward in relation to what needs to be done?
Capacity is situation specific.
Is it?
Is being able to understand something, retain information, and weigh up the pros and cons and come to
That's
an
the
informed
process
decision.
for assessing capacity.
Yeah.
But it doesn't define it for me though, does it?
The capacity to do what? To manage your own money or to make a decision?
So we need to go back to, yeah, as I say, 19/20 senior court decisions looking at practical situations of people that are affected on the ground and whether they actually have capacity or not. And the court's saying, is it decision specific or is it actually, does it go beyond decision specific? Yeah, because it's about people being truly able to understand the world that they're living in and whether in fact they can truly weigh up the issues going forward. Let me try and help you if I may. Yeah? Mental disorder is defined for us by Section 1 Mental Health Act. Is it not? Which I think is what you were referring to, yeah? 1983 Act. Mental disorder means any disorder or disability of the mind, and mentally disordered shall be construed accordingly. Okay? However, mental capacity for the purposes of the Act talks about a person who lacks capacity in relation to a matter if at the material time they are in fact unable to make a decision for themselves in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. Yeah? You all knew that, didn't you? Yeah? Because linked to this, yeah, as in the statutory definitions, is some underlying principles, are there not? Yeah? I'm looking for reassurances, but I'm not getting them. Yeah? Are there any underlying principles in relation to the Mental Capacity Act? Presumption of capacity. Well, how many are they, and what is their legal status? Okay, because the point here is what the courts have said repeatedly in the last 5-6 years, is that there is a fundamental failure by health and social care professionals to A, understand what those principles are, and B, secondly, to then apply them. And so if you don't know what they are and you don't know what their relevance is in terms of application, how can you then ensure that you're doing what needs to be done for P? Yeah? So anybody want to help me? I'll give you a clue. So we've got the first one, which is presumption. Well, presumption, yeah, so we've got a starter for 10 here.
Best interest.
Yeah.
Least restrictive.
Best interest, least restrictive.
Unwise decisions.
You can make an unwise decision.
And all practical steps are taken.
All practicable steps to facilitate or assist an individual to make a decision, even where that decision amounts to an unwise decision. That may mean that they're returning to a vulnerable situation, or they're choosing to live in an abusive relationship, or otherwise. Yeah, as examples in point. Because what the courts say is if you don't know what they are, then how can you then work with people that lack capacity if in fact you're not trying to ensure that they are applied? Because what's their legal status? Are they just there because it's a jolly good idea? Or is it within guidance or within a code of practice? Because what we see is that these are set out for us in statute at section 1 of the MCA. And what the courts keep coming back to as a default position is because these are set out in law, then they have to be followed as a point of law. So can we see in your assessments of capacity in relation to your service user group, in particular, that you have demonstrated this in terms of what steps you've taken? And how far have you gone to do that? What does that look like? Yeah? Because what the courts would say is if we can't see evidence of that, then it would suggest that it's not happened. Yeah, so I think what we're saying is we need to remind ourselves as to those statutory principles going forward and within the context of the definition of incapacity and or disorder.
So would it be better documentation?
Well, before you get to documentation, you need to actually understand what they are, don't you? And as a registered healthcare professional, is it acceptable that you're operating in a context of not knowing what the statutory principles are that you need to apply? Because what the courts tell us is that in looking to establish what's happened, where there's no evidence of this, what we often find are situations whereby healthcare and social care professionals are drawn into a situation that they are concerned about an individual who may put themselves in some degree of vulnerability. What the courts are saying is, well, that's their shout, isn't it? Because we have an underlying presumption here of capacity. And it's a term that we'll go on to talk about where it talks about a protection imperative. Yeah, so you get drawn into the need to protect when in fact what the courts are saying is you should be allowing people to make unwise decisions. So we're going to try and illustrate this with a couple of cases. Richard, you're probably better than I am on this one, so over to you.
Well, the case of Dunmore and Bergen, it's actually quite a recent case. It was a case where there was a compromise agreement, so that effectively a settlement had been reached. The facts of the case were quite clear in that what had happened is that there was an issue regarding capacity, but the claimant solicitors at that time basically went ahead and got the approval. So the claimant suffered a brain injury in a car accident, and they instructed the solicitor to bring a claim for personal injury. So when it says it's settled for personal injury, and at 12,500 in the day of trial, it was clear, it wasn't that it was a hidden brain injury, it had been flagged up and there were issues at that time. So I just want people to know that when we talk about this, the solicitors who had previously settled it, there were issues about her capacity at that time, but it wasn't investigated and they settled it for 12,500. It was held that the claimant had not lacked capacity at the time the consent order was agreed and being given sufficient clear explanation of the terms of the order which he'd understood. So the judge made it clear that he'd reached a decision by asking himself whether the claimant had capacity to enter the consent agreement rather than she had capacity to conduct proceedings as a whole. Now, that isn't the end of it, really. The case raises a number of issues, and those are whether, obviously, the test for legal capacity, it's not a medical decision. The medical evidence is one factor. There are witness statements and oral testimony if necessary. But the tests will lay out in Master, Lister and Bailey whether the previous compliance order could be set aside for want of capacity. Those cases establish the proper question is whether the individual in question has the necessary capacity to conduct the proceedings or to put it in another way to litigate themselves. In the circumstances, Ward LJ considered that the first instance Judge Silver J had fallen into error because he'd approached matters too narrowly by treating the relevant transactions as the actual compromise, which was negotiated outside the court. It was flagged up and it should have been. And since the compromise itself was not self-contained, a contained transaction, but part of a parcel of proceedings as a whole, question was not the narrow one of whether Clem had capacity to enter into that compromise, but the broad one, whether she had the capacity to conduct the proceedings. So he had to look at more than one issue, really, when determining this. So that was the issue.
But that in part links back to your point about is capacity decision specific, because what the courts would say is, yes, it is, but actually that needs to be understood within the person's ability to weigh up all relevant information. So while she may have understood one element of it, she didn't understand the broader implications. And that was the matter in the case of the Crown versus Cooper in 2009. Yeah, and you've seen that repeated subsequently in a number of follow-up decisions. Got Lachlan, which...
Right, well, Lachlan and Singh, I don't know whether it's downloaded. I don't know, do you want to see if it's downloaded?
Just to have a look for us.
Because I've got some pictures of mine, and I'm really sorry. We did IT glitches, with no excuses, and I've got a large gin and tonic on the side there for me. But it would be nice if we could get it, because I did Lachlan and Singh, which was a very, very interesting case. Bear with me. We'll just see if we can get it on. Downloading earlier.
While we download that, can you just go back to the previous one?
Yeah.
So I mean, I didn't quite get the whole thing. So the lady had an accident and got a personal injury claim, and it was approved at the first trial for £12,500.
Basically, there were issues regarding her capacity at the trial. The facts were that there were issues regarding mental capacity there. It went ahead, and it was not just a contract, whether she had a contract, but whether she could use all of the proceedings effectively. So that was it. Now,
so who made that afterwards? It's obviously the first court.
what happened was that subsequently she went and got separate advice from another set of solicitors, and basically they went back and they sued the initial solicitors. So effectively it was a negligence claim against the initial solicitors for failing to recognise. So that was it. Yay! Right. Okay. If we just go on to
Just a little bit out of the context. In that case, why wouldn't it be possible as a penalty or the thing for the first solicitors?
well, the first solicitor will be sued, and their indemnity insurance, their professional indemnity insurance will basically meet that. So what you tend to find is that it just means that when you've got cases like this, in some cases where there are issues, sometimes you find that even defendants now are saying, well, let's get it approved by the court. Just because that way you can't go back, you know what I mean, and be dealt with. It's settled once it's, you know, once you've gotten approved by the court. Here it was settled before the door of the court, so you know what I mean, it wasn't a judgment. So when you've got situations like that, they want to get it approved, basically, the settlement where there may be a mental health issue or, you know, or a capacity issue. Right. So
right to Sedge.
Yeah, we'll go to Mr. Sedge. Mr. Sedge. Sedge and Prime. So Mr. Sedge was basically very severely injured. He was injured in a motor car accident on the 2nd of June 2008. He was a pedestrian who was run down in Sheerness in Kent. Effectively, he was walking across. It was a semi-pedestrianised area. Somebody came at 20-40 miles an hour. We say 40 to down to 20. And it hit him, threw him into a bollard. He suffered very serious head injuries. He was doubly incontinent. He was aspasic. He had major issues. He was unable to mobilise independently, wheelchair dependent. And basically he received some rehabilitation, but he then went to Little Oyster Care Home. And Little Oyster Care Home is a lovely place with a lovely sea views, fantastic. There was nothing wrong with the care. He wasn't focused on people with brain injury or learning disorders. It was a very mixed bag of clients. So there was nothing there. We looked at this, and having settled liability in 2011 on a 75-25 basis in his favour, we put a case manager in, and basically been there at that stage for roughly 7 years, well, I think it's 7 years, something like that, and he had little or no support or assistance. Therapies had fallen away, we reintroduced therapies, but we looked at it, and the case manager came back to us and said, we have made real gains, and between effectively September of the year we introduced it to the end of that year, we saw real gains with speech and language, physiotherapy, and occupational therapy, and he was making real gains. He was interacting, whereas before, and again, not wishing to criticise the home, it was effectively parked, you know, a lovely view, but if you're there parked looking at the sea for hours on end, or in the TV room, he wasn't going to agitate. He was a nice client. We all know the sort of person, and we thought we could do something more for James. We thought that we could get him a better result, and the case manager said that there'd been real improvements. He was interacting, he was showing awareness, he was going out on trips, whereas before he'd been socially isolated. His mother visited him on a regular basis, but the relationship between the care home and his mother was very, very poor. Very, very poor. He had younger siblings, and they didn't like the clinical environment in the care home, so it alienated the family, whereas after we got a case manager, initially we took him to his mother's home, where he could take part in family activities, barbecues, etc. So he became part of the family again, rather than being socially isolated. And we looked at it and we said, well, how do we get this man out? And we looked at basically a best interest meeting, and we said, well, what do we need to do? So he was funded by the Primary Care Trust at that time. They paid for no therapies, as I'd already indicated. So we basically arranged a best interest meeting, which effectively had the therapists that are already identified, speech and language, occupational therapists, speech and language therapists, the case manager. We got an independent advocate for the claimant's mother, who was Doug. I'd recommend him if ever you need someone. So we got someone to come in as well to do that, and it was chaired by the Primary Care Trust, effectively, who looked at things. And what we did was we had this meeting, and it concluded that the claimant's best interests were served by a trial of independent living in the community. So, having done this, we then went back to the defendants and presented the best interest meeting, which is, whilst it isn't the same as the test in legal proceedings, it is extremely persuasive if you've got a clinical team who basically saying this man has made real progress and he can make real progress. And ultimately, if it fails, what have we lost? If it fails, this man has come out of being in a care home, which is effectively his prison. You know, it might be a nice prison with sea views, but it is still a prison. He's not getting the interaction, the stimulation that we all want. So, what we did was we asked the defendants, will you agree to this? We rented a house, we were proposing getting carers. Unfortunately, the defendants weren't prepared to agree. There was a tactical reason why they didn't want to agree, because on a tactical basis, they don't want to set up a regime. They want to basically say that this person was ideally suited, a he'd been in the care home for 7 years. There were no issues. It could be done by way of top-up. But we wanted to get this man out of there so he could be with his family, so that he could be in the community, and so that we can give him a quality of life. And that, you know, as lawyers, we're often criticised, personal injury lawyers, but ultimately we work with everybody and the clinical team to try and achieve the best for our clients. And that's what we did in this particular instance. And that's why I think the outcome I'm particularly proud of in this situation. So we went to a contested hearing, and it lasted a day. The judgment itself doesn't really deal with the mental capacity issues, because about half of that whole day was spent with mental capacity issues, whether he needed a welfare deputy, whether he, whether the test for the best interests is the same as reasonable needs on the Queen's Bench. So we looked at all these issues, really. So
Who was the defendant? Was it the car insurance people?
Yeah, it was the car insurer. It was the insurers. It was actually it was Aviva.
You mentioned PCT, didn't you?
Yeah, the PCT had fundraised stay at the care home.
But the insurance.
Yeah, but the insurers. And that's why the insurers wanted him to stay there. They wanted they wanted the state to pick up the tab. They wanted just to pay a top up. Okay. So that was the reason they wanted to stay.
And their argument as well, though, was that because the best interest meeting had took place, they suggested that the best interest meeting was an attempt to undermine the process and create an uneven level playing field in terms of...
They said it sets up a fait accompli that a trial judge faced with an established regime would not be able to set it aside. We said if it tried and failed, that would be the evidence, you know. And also we said that effectively it wouldn't be a level playing field if the status quo remained as it was, because the claimant doesn't have the chance to trial it, to see what it is, to counter any arguments by the defendants. So to that extent, you know what I mean, it was not a level playing field if the defendants had got their way. Now, the argument was we asked for more than 300,000, but we got 300,000 as it was, and that was found by the judge to represent a reasonable proportion of the likely judgment, and that allowed us to basically move the claimant into his own care home and basically establish a regime. And I think that goes to show how best interests can be used effectively to assist the lawyers, to assist the client, and ultimately a best interest is what is the client's needs, what best suits the client's needs, and how do we deliver that. So for us, it was using the clinical, what you do every day, and how we bring it into the legal to assist us in getting the best outcome for the client.
Did the PCT still agree to pay that?
What happened was that when he came out, the local authority, we then applied for local authority funding, but majority of his care and accommodation needs were met from the interim payment we obtained. So it gave him greater flexibility. The PCT dropped away once we moved out of the care home. And to be honest, there was always had been, and it was one of the issues that we had, whether or not he had a continuing care need, because whilst he was doubly incontinent, all the rest of it, he could feed himself. There were no other medical issues of note. So I was surprised, to be honest, that the PCT had continued the funding. There was no therapies in place, but once he'd moved to the community, or was about to move to the community, another assessment was undertaken, and it was deemed not to have a continuing care need.
Because 7 years is a long time to wait for compensation.
Well, what happened was his mother rang us up about a disability claim. So she rang us up on the anniversary of the third anniversary of his claim, saying, I've got my son and I want to claim mobility. And it's only when we dug a little deeper that we found out that this gentleman had been knocked down. So The 7 years, I would like to point out to everybody, isn't of our delay. Effectively, within 12 months, we'd issued the proceedings, and within a year and a half, we'd settled liability. So we issued in 2010, and this case settled in 2013. And every single aspect was fought, you know. So it was not an easy case because the defendants were not happy about it, but ultimately it's about getting the right outcome, and it wasn't the right outcome particularly, and each case is fact specific because he made a very good response to the introduction of care and support. If he hadn't have done, then it might have been a more of a difficult or nuanced argument about moving him out of the care home into his own house, because the argument then becomes what actual benefit does he receive. But in this particular instance, there were real and tangible benefits that he got from moving out of the care home into the community, you know, and his family, their interaction. I've already highlighted the problems that he encountered when he was at the care home. Their relationship with the care home manager was not good.
Just one question.
Yeah.
The complexity of these cases and the amount of time you spend digging up information and things.
Yeah.
How do you charge, and who pays for your...
Right. We charge. This was on the rules have changed. The government have made life a lot harder for personal injury lawyers, but effectively we charged by the defendants paying because we were successful at the liability trial. It went to a contested trial. They offered nothing. We got 75%, which is what we said it was worth in terms of liability percentage. So we met our own. We got indemnity costs. We then asked them for an interim payment of £200,000. They rejected it. We then had another contested hearing, got £175,000. We then asked them for £300,000, but we asked them for £450,000. They refused to get it, we got £300,000. I think you see that it was heavily contested at each and every stage. When it came to disclosure, the carers, they wanted the harvester's invoices for taking him out for meals. They wanted the blue badge application for a man who's doubly incontinent in a wheelchair. I'm not kidding you, it was a very hard-fought fight. But ultimately, they paid. They did pay because at each stage they'd put obstacles and ultimately, what I would like to say, and we'll come on later on to other developments. I don't want anyone to come away from this thinking that personal injury lawyers just fight. We do fight, and I'm very proud to fight for people we support and act for. But at the same time, most of the time, we work with insurers to get the best. We use the rehabilitation protocol. There's the serious injury protocol, which I'll touch upon later on in terms of what is coming for more serious injuries. And the aim is to try and get the best outcome. And if you can work with an insurer, you can look at statutory funding, you can get people out, and you know, obviously that benefits the NHS because we're getting people out of beds into the community. We're working with the insurers to get rehabilitation, to get the best outcome. So when you can work...
The PCT paid for this chap's care for all those years.
Nobody seems to have reviewed him. He was reviewed, and to be fair, before we'd taken over, his mother had challenged, because the PCT had indicated at an earlier stage that they were going to remove his funding, but she appealed it and they kept it. So,
but why didn't the insurance pay from right at the beginning?
Well, the insurance, why didn't they pay at the beginning? They were 3 years down the road before that we got involved, so he was already in the care home at that stage, and it was being funded at that stage, and it was only once the liability had been dealt with that effectively they made any payments, and even then we had to issue proceedings to get them to make a voluntary payment.
Conscious that time's making fools of us, we need to wrap this up. So what I would simply do is just a final point, is that there are a number of other cases that we have set out in the materials. And what we'd say to you is that we've asked that these be circulated and made available to all who are in attendance. But what we will make sure is that you get the perfected copy.
The perfected copy has actually pictures of James, it has pictures of the care home, it has pictures of the seafront, and I would have really, and I do apologise for our technical glitches, because I would have liked to show you, because it actually does help and gives some sort of, it sets the scene, so to speak, as much as it can do, about the events. What I want people to take away from this is that personal injury solicitors, we're a much maligned breed. We're a much maligned breed. Sometimes unfairly, sometimes correct. But in cases such as this, we can actually add value, and I'm very proud of this case because we basically made a real difference to not only his life but that of his family as well. So thank you very much for listening.
Thank you.